Hello and welcome to the in-news series of DRISHTI IAS. I am Pooja Devedi, and in this segment today we are going to discuss about the freedom to move freely and reside in any part of the country. This topic is important from the perspective of prelims and also from the perspective of GS mains papers. So let's begin with the topics of discussion that we're going to look. So starting with the news, let's first talk about why is it in the news. As according to this article, you must see externment orders must be issued only in exceptional case. It is observed by the Supreme Court by a bench led by Justice Indira Banerjee and Justice Subramanian. They have said that the right to move freely in the country and reside freely in the country should not be curbed on flimsy grounds. Let's first talk about the background of the entire case. The background comes because of the case of journalist Judgement Khan, against whom several FIRs were launched, and these FIRs were lodged as well as an externment order was passed under Section 56 Clause 1 Subclause A and B of the Maharashtra Police Act. What is the issue entirely? If we talk about the issue, the journalist Judgement Khan, he actually went forward with certain queries under the Right to Information Act for misappropriation of funds in madrasas, and accordingly, as observed by the Supreme Court, retaliatory measures were taken against him in the form of first information reports or FIRs. And as an externment order, he was curbed, his movement was curbed, and he was actually blocked from entering the premises of Amravati in Maharashtra for 1 year. And this is the entire scenario, as we all know that it is a fundamental right to move freely across the country, however we want, and of course reside in any parts of the country, and that is subject to certain restrictions. And this entire case is actually because he filed an RTI because he wanted to know about the misappropriation of funds in the madrasas, and FIRs were launched against him. This is the entire issue. And if we talk about the judgment says that the threat to lodge a complaint cannot possibly be ground for passing an order of externment, and that is under 56 of the Maharashtra Police Act 1956. The interesting thing about this case is that the queries which were filed or the issues which were flagged by the journalist, those issues were actually in place. That means there were truth to the entire issue that yes, the funds were being misappropriated. And the cases were also an attempt to teach the journalist a lesson to stifle his voice, a threat to his freedom of speech and expression, and thereafter a violation of the Article 19. Also, even if the FIR was actually lodged on good faith, that means if they were true, then also there was no need for externment order, because Section 56 to 59 of the Maharashtra Police Act, the externment order can only be taken into account if no remedies are possible through judicial means. Justice cannot be reached through judicial means, then only we can go forward with externment orders according to the section. So, Article 19, if we talk about, it provides us certain freedom in the form of freedom of speech and expression, to assemble peacefully, freedom to form association, right to movement, that is 19 Clause 1 Subclause D, and also right to residence, that is 19 Clause 1 Subclause E. So, we talk about both these together. Generally, they go along together. And in the Khadak Singh case, Khadak Singh versus State of Uttar Pradesh, it was actually said by the Supreme Court that it is the right to locomotion in any part of the country, subject to certain restrictions, in whatever form or however we want to move. This is the first thing that we need to keep in mind. And there is also one, we will talk about the other case. This one is Khadak Singh case. Khadak Singh versus State of Uttar Pradesh. Okay? Keep that in mind, of 1963. Wherever we want and however, do keep these two words in mind. Then, right to profession is also there. Okay? One thing that we need to understand from the perspective of prelims, that the right to freedom of movement and residence is applicable only to the citizens of India, not foreigners. Keep that in mind. Also, Article 19, Clause 1, Subclause A. Under it, it is interpreted that right to information is a fundamental right, because right to freedom and expression can only fructify once we have certain information about certain cases. If I do not have any kind of information, how will I go and execute my right to freedom of speech and expression? So, under it only, right to information is a fundamental right. Any retaliatory moves such as FIRs or any threat of externment will possibly and definitely have an effect on my right to information, because of course, if I want to know something, as I said, I want to know as well. And then right to communicate, print and advertise information. That is also my right to freedom and expression. If the journalist wants to know about the misappropriation of funds in the madrasas in order to express his or her opinion through the newspapers, what is wrong in that? It is a fundamental right. It is guaranteed by the Constitution. Then, right to move freely throughout the territory of India, as discussed. And the freedom of movement has two dimensions. First is internal, that is right to move inside the country, and external, that is right to move out of the country and come back and reside in the country. That is Article 21. Of course, right to move freely also has reconsonance if we talk about with right to life and liberty under Article 21. Okay, so this is the set of fundamental rights that are important from the perspective of this segment. Let's move forward and talk about certain challenges. Certain challenges with respect to fundamental rights occur. Fundamental rights are a basic structure to the Constitution. Basic structure of the Constitution, it is guaranteed by the Constitution of India to us that these fundamental rights are actually have a negative effect on the powers of the state, right? Because this is our right. According to the fundamental rights, we need to live in a manner in which our freedom is respected. Okay, so subjectivity is there. Subjectivity in terms of what are reasonable restrictions. If I am going to tell you about a case, here I will use it. Okay, subjectivity, reasonable restriction. First is the case of state of Uttar Pradesh versus 𝐃𝐫𝐢𝐬𝐡𝐭𝐢. Okay, this we will discuss. State of UP versus 𝐃𝐫𝐢𝐬𝐡𝐭𝐢 of 1964. Okay, before that, just keep in mind that a right to move freely and reside, it has certain restrictions on two bases. First, interest of public, that can be public law and order, public morality, decency, and the second one, the interest of scheduled castes and scheduled tribes. Okay, so any land which belongs to scheduled castes and scheduled tribes, especially in the regions where they depend on the resources of the forest and their identity is community land based, the right to residence and move freely can be seen as a restriction, because it might change the economical, social and demographic status of that region. Second is interest of public, where this case comes. State of Uttar Pradesh versus 𝐃𝐫𝐢𝐬𝐡𝐭𝐢, where it was stated by the Supreme Court, it was stated as in the sense as a judgment that the right to move freely for a prostitute, it can be curbed on public morality. Okay, keep that in mind. So there are reasonable restrictions. Another thing is the emergency provision. If we talk about Article 358, it suspends the 6 freedoms guaranteed under Article 19. And this you will learn with the help of 44th Amendment. 44th Amendment of 1978, that on the grounds of war and external aggression only, the 6 freedoms guaranteed under Article 19, it will be, of course, suspended, and it will come back into force after emergency ceases to exist. Okay, and not on the basis of armed rebellion. Keep that in mind. That was stated by the 44th Amendment Act. So the emergency provisions and the subjectivity, what is actually in the interest of public, what is actually in the interest of scheduled tribe lands and scheduled castes, that is also very subjective. But it is a good thing that these cases come to the fore every now and then, because the judiciary keeps on interpreting the constitution, which is very important for the constitution to be a live person. Yes, it's not rigid. It's kind of a live constitution. This constitution is very lively because it keeps on getting interpreted as well as growing itself. It's very important for a diverse country like ours, India. Moving on, let's talk about the way forward. Democratic setup always should be respected. That means democracy is where everyone has a voice, everyone has a right to life and liberty, and the balance should be done on individual liberty balanced with law and order and public interest. Whenever there is a clash between individual liberty and public interest, the latter always has a more profound findings than the former. Keep that in mind. Okay, individual liberty is there, but public interest should also be given proper consideration. And which one should thrive? The one which has a majority and more intense impact, that is basically the public. Okay, and here if the individual liberty, such as having RTIs, which will of course be beneficial to the society but not detrimental to it, how can it be curbed? When the liberty has no ill impacts, how can it be curbed? Okay, then also checks and balances. Checks and balances in the form like, of course, the state, if becomes all powerful and no provision of checks and balances such as the judiciary exist, it will create a very detrimental effect in fact on the society. So we do not need our society to decompose. We want our society to grow. No stagnation should be there. No all-powerful and unburdened power should be put in the hands of any one organ of the polity. That is what is happening in our country, that we are balancing it through legislature, executive and judiciary. So let's move forward and look at our mains-based question. Discuss in detail the provision of right to move freely in the Indian Constitution in 250 words. So that's it for today. Tomorrow we shall meet again with another segment. Until then, stay updated and thank you so much for watching.